with the support of the British American Business Council of New England and the National French American Chamber of Commerce Network. First, let's see some housekeeping items. This webinar will be recorded. The presentation will be roughly 30 minutes long, followed by a Q&A. Every participant is on mute by default. If you have questions, please use the chat window and address them to Ludivine, FACNI. Ludivine will invite you to ask them directly to our speakers during the Q&A. Finally, if there is a technical glitch, please reconnect with the link that we shared with you this morning. And now the floor is yours, Scott. Scott, we cannot hear you. Could you please unmute?
Yeah, I can unmute. My dog was barking. Sorry, she'll bark again. Count on it. Anyway, sorry about that. So today we're going to be talking about COVID-19 and its substantial effects on the current immigration landscape here in the United States. I'm joined by two of my senior associates in the Boston office. If you could just advance the slide, Erin Brummer and Alexandra Branzburg. We are all with Fragomen, which is a very large global immigration services provider. We have a large office in Paris, as well as 19 offices here in the States. All we do is immigration. On to the next slide. You will see from the map here, just kind of an overview of information that you receive every day. You know, bottom line, this is affecting everyone everywhere. And as will be discussed later in the slides, essentially all travel is shut down and all consulates for all countries, for the most part, are not issuing visas for travel anywhere in the world. So we'll walk you through that as we go. Next slide, please. There's three essential themes that countries have been following to protect their citizens from folks coming in from other countries. One is entry bans, and you can see the US, as well as essentially most other countries around the world, have set up travel bans. One of the most drastic ones, and you know, certainly very effective, was India's ban of its own citizens. So India is one of the few countries that is not allowing its own citizens to come back into the country. The US is allowing, and we'll talk about that shortly, folks to come in, citizens of our country, lawful permanent residents, as well as across the Canadian and Mexican borders, people coming in to do work. So, you know, there's pros and cons to that, no question, but comparatively, we're fairly liberal as opposed to some other countries. Quarantines are in effect. Most people who come into the United States, just back up to the prior slide, please. Most folks that come in are subject to a 14-day quarantine period, and you can see the list there of the airports through which folks can currently come into the United States as effective, actually not as March 30, but as effective yesterday. And then last thing, you know, waivers is very, very difficult. You pretty much have to be a medical professional who's got some specific skills to get any kind of a visa appointment and facilitate travel into the US for employment right now. And with that, I'm going to turn it over to, I think it's Alex. Let me just look on my list here.
Thanks, Scott.
Yep, thanks, Alex.
Alexandra speaking. Yep. So as Scott mentioned, there is some travel that's allowed from Mexico and Canada, and it's only essential travel that's allowed. So essential travel would be if you're going to work or study in the United States, assuming you already have that authorization, or for a study you have to have an approved OPT I-20. You could travel for medical purposes. There's going to be some additional screening. If you're trying to come over as a visitor, that's deemed not essential. So, and of course, if you're a US citizen or a lawful permanent resident, then you can come back to the United States. On the flip side, say you're coming into the United States on visa waiver and you can't leave to go back to your home country. Usually with visa waiver, you can't get extensions, but right now there's something called satisfactory departure that people can use. It's a 30-day extension. You can get it by going and contacting deferred inspection. And then after that 30 days, if you still are not able to travel, there's an additional discretionary 30 days. As Scott mentioned, across the globe, a lot of consular posts are not processing visas right now, except for on an emergency basis. And it really is different with each consulate, but if you go on the specific website, each consulate website has updates. And it's unknown when the consulates are going to be reopening at this time. So for that reason, we are advising people that if they travel abroad and they're not, a U.S. citizen or a lawful permanent resident, depending on their circumstances, they might have difficulty coming back into the United States. There are some folks who have already made their appointments for processing visas and their appointments have been canceled. If their appointments are resuming, there could be some backlog, but there's a possibility that they might still be able to reuse their MRV visa fees so that they don't have to pay again. We can go to the next slide. This slide is talking about USCIS filing. So when you file a petition with US Citizenship and Immigration Services, US Citizenship and Immigration Services, or USCIS, they'll review the documentation, and if they have any questions, they'll reach out for additional evidence. It's called an RFE. And usually they can be pretty document heavy, and it takes companies and individuals a lot of time to gather the documents and respond depending on the type of request. So USCIS has granted extensions for certain requests like this for an additional 60 days if their request was issued between March 1st and May 1st.
Hey, I'll take this one. So unlike most countries around the world, the Immigration Service, the USCIS, is still open and still accepting filings. So if someone is here and they're in valid status and they're working, their status can be extended because the USCIS is still open. This has been good and bad. It's a double-edged sword. On the one hand, it's keeping a lot of people like our law firm and our employees employed and busy. And it's also, sort of business as usual in terms of people being able to continue to work and to stay here. On the other hand, the USCIS is a paper-based agency, unlike the IRS and most other US government agencies. Everything has to be done by paper. We file applications every day. We still have folks, a skeleton crew going into the office to make photocopies and scans and et cetera. And we're doing a ton of stuff, as Erin and Alexandra can tell you, from home. We've got every one of our attorneys has a printer and a scanner and checks made out to the USCIS, et cetera. One of the things that we've been trying to do is get the government to allow us to use electronic signatures. We have not been successful. They'll let us take a copy of an original signature, but it still requires us to send a lot of paper around. So if you are working with counsel or on your own to file immigration petitions, understand it's a challenge right now, but remains an obligation. We still have to comply with the laws as far as filing timely extension petitions. Okay, Erin, sorry.
No problem. So one of the other actions taken by US Citizenship and Immigration Services, or USCIS, that has raised a lot of questions with both employers and non-citizen employees is the suspension of premium processing. So premium processing is the immigration agency's expedited path to review applications that are submitted. And what this means is for an additional government filing fee, the government will return a decision or a request for evidence within 15 calendar days. A lot of people take advantage of this so that they can receive a speedy decision on their application or facilitate changing employers more quickly. Now that premium processing has been suspended, it means that applications submitted to this agency can now take several months, and that timeline fluctuates and is difficult to predict. This suspension of premium processing also means that any applications submitted or selected via a new online registration system for first-time H-1B applicants this year will also not apply and will, again, face the same several month-long processing window as opposed to receiving a decision more quickly. As both Scott and Alex mentioned, the government is still, Immigration Service is still accepting applications for review, but where issues come in is that this may hinder someone's ability to change employers, as well as extend their status in a timely manner. Another kind of service that has been suspended by USCIS are any form of in-person interview. This includes interviews for permanent residents or green cards, as well as naturalization ceremonies and ASC appointments. So ASC is for an application service center, where someone would have to go attend an in-person appointment to have their biometrics taken in order to receive a benefit on a pending application. While our firm as well as employers are pushing for USCIS to waive this requirement, as of now, the suspension is still in place, at least until May 3rd, although we do anticipate that this could continue. What this means is that employers and applicants can expect a backlog for when they would be able to resume and attend a biometrics appointment or green card interview or other in-person service. One recent development that is a benefit only for individuals who have previously applied for an employment authorization document, or EAD, is that if you've already gone through this process and USCIS has a record of your biometrics, so photograph and fingerprints on record, then that can be used for a renewal or extension of your current work authorization.
Thanks, Erin. Yep, I know. If we could go to the next slide, we're going to talk about I-9 requirements. So for folks of you who don't know, I-9 is a form where employers are required to make sure that their new employees are eligible to accept work authorization in the United States. And it has to be done within 3 days of onboarding that employee. And one difficulty with the situation right now is that typically those documents that show work authorization have to be reviewed in person. And those documents, they might include an I-94, an approval notice. There's a whole list of specific documents. So USCIS and the Department of Labor are implementing relaxations, and here DHS has allowed employers to just look at those documents remotely for the time being. And then they would input on the I-9 form itself COVID-19 just to delineate that it's been reviewed remotely, and then physical inspection can take place later. We could move to the next slide. Thanks so much. So right now, the employers will still have to look at those documents physically, and the remote procedure might be carried out within 60 days from the DHS notice of the 3 days that the national emergency is over. So we really just don't know when that's going to be. Note that there's a caveat that if there are employees that are physically present at the work location, then those documents still do need to be reviewed in person. We can go to the next slide. E-Verify is not relaxing the 3-day deadline for initiating E-Verify. If there's a query and maybe something is delayed due to COVID-19, then employers are instructed to write COVID-19 as the basis for the delay. And there's an option for this. So when you go into the other field dropdown, you're able to input that. If the E-Verify results in a TNC response, which is basically when they look for more information to be able to confirm the employment authorization, then the employer would have to notify the candidate right away. And we can go to the next slide. And, of course, there could be some delays in responding. There are extensions for the time frame for when that response can take place. However, the time frame hasn't actually been given, so we don't know when that will be. And of course, DHS reminds employers that they cannot take any adverse action against the employees because the E-Verify is in the interim status. So if it's just pending and you're not able to get those documents in, no adverse action until you're able to actually submit something, depending on when that extension timeframe is. Scott, do you want to talk about it?
Erin?
Yep. So a big question is what happens to someone who is a non-citizen if there is a reduction in wage, hours worked, or a furlough. And the main takeaway is that employees in certain visa categories must be treated differently because of wage obligations mandated by the Department of Labor. So for the first category here, any employee in H-1B status, if there is a reduction in wage, their salary cannot drop below the prevailing wage for their geographic location and occupation. Some other considerations to keep in mind is that if there is a wage reduction or reduction in hours worked, that can require submitting an amended petition to USCIS, essentially where there's any material change in the terms of an H-1B employee's job duties and employment. So for any other employees in a different visa category, there are still considerations, although not as drastic because there's no wage obligation with the Department of Labor. But something to keep in mind is looking at whether foreign national employees, so employees in a visa status, are being treated the same as US citizen or permanent resident employees where there is a wage reduction. And the reason we want to flag this is because any sort of disparate treatment could raise discrimination concerns or complaints. Similar with wage reductions, a reduction from full-time to part-time employment also needs to be examined to determine if any action needs to be taken. If there is a reduction from full-time to part-time employment, which is typically part-time is considered less than 35 hours per week, then that is considered a material change for immigration purposes, and an amended petition needs to be submitted to USCIS to put the government on notice of these changes. This applies again, for any type of visa category that does also have a Department of Labor wage requirement. So when can someone move into a new role where there has been a wage or hour reduction? And that's upon government receipt of the amendment filing that reflects the reduced schedule or rate of pay. Government approval is required before an employee may work at a reduced schedule or wage for other visa categories. H-1B employees do have benefit from something called portability, meaning they can move into that new position or kind of new schedule upon receipt of their application. Similarly, furloughs without pay just violate wage obligations that an employer has to attest to when filing an application with the Immigration Service and the Department of Labor. Other issues that could come up where there is a furlough is that for employees in another visa status, say outside of the H-1B context, that could be an L1, TN, or O1, this may cause a violation of their current status and impact their ability to extend their employment if they're no longer working. They're not subject to wage rules, but again, this could cause issues in terms of the continuity of their ability to extend their stay and their work authorization. There is kind of a silver lining, although short and subject to certain rules, but if someone is laid off and they are a current visa holder, they do have a 60-day grace period from the date of their layoff to either find a new employer to sponsor them or apply for a change of status to another visa category.
Thanks, Erin. So now we're going to turn and talk about implications for this year's H-1B cap season. So typically for a candidate to work in H-1B status, they have to be entered in the H-1B cap lottery. There are some extensions there. And in the H-1B cap lottery, it was really different this year. Instead of just filing a petition with USCIS and hoping your case gets selected, instead there was an early online registration. So USCIS received 275,000 unique registrations, and the selection rate was about 30%. And there's now a 90-day window to file the corresponding H-1B cap cases with USCIS that were selected in the registration. LCAs are a pre-filing requirement that are necessary to be able to file the H-1B petition. You've always been allowed to post an LCA to notify workers that an H-1B worker is coming electronically, but now a lot of more employers are relying on this because they're not able to get to their offices, or their offices are empty, so they're not able to do physical posting. So electronic posting was an option and does continue to be an option. Premium processing. So these H-1B cap cases will not be premium processed because USCIS has suspended that service. What that means is that they could take a long time to be approved, and typically with an H-1B cap case, the earliest start date is October 1st, and this year will be October 1st, 2020, but there's a real possibility that cases will not be approved by that time if they get an RFE or if the adjudication is somehow delayed. What that means is for folks that might be in another status here in the United States, just to make sure that they're going to be able to maintain that status until they're able to switch over to their H-1Bs. This also really does affect H-1B cap gaps. So F1 students who apply in the H-1B lottery and selected, they can still benefit from cap gap as long as the corresponding H-1B petition is filed before their OPT or their STEM OPT EADs expire. And with that, they can still continue to work after the EADs and OPTs have expired as long as their H-1B gap petition is timely filed. And then as of October 1, however, if they still don't have the approved H-1B petition, they can remain in the United States, but they wouldn't be able to work. If we could go to the next slide, I'll talk a little bit more about students. So there are some students who are currently outside the United States. Maybe they were in school and they left because their school has shut down, or there's travel bans and things like that, and they're not able to apply for OPT. You have to be in the United States to be able to apply for this benefit, and right now there are no provisions to be able to apply for it remotely. What that means is that there are a lot of foreign students who are outside the United States who might not be able to benefit from that OPT filing window, and right now we're not seeing that there's going to be any recourse.
Okay, some final thoughts. These are just some overarching concepts that people want to be aware of, but sort of big picture, as was mentioned on the call. One, the consulates are closed, so it's very difficult for anybody to immigrate to the United States right now from abroad, either temporarily to work or to get pick up a green card at a consulate abroad. Just is what it is, and it's the same for most countries around the world. On the other hand, the U.S. is different. Most countries around the world, the immigration authorities are closed. In the U.S., the immigration processing centers are actually in some remote areas in Vermont and Nebraska, California and Texas. So because they were set up there many years ago, they are able to continue to operate under the current restrictions. Most countries have applied a 90-day across-the-board extension to foreign nationals' status. The U.S. has not done that because they're continuing to accept extension applications or change of status applications. An organization called the American Immigration Lawyers Association has actually sued the government, asking that a 90-day blanket extension be implemented. I don't know whether they're going to be successful or not. It's in the federal courts right now. One thing to remember is as things hopefully relatively soon start to open up, they're not going to open up everywhere at the same time. So just because a consulate is open in a country doesn't mean that the documentation necessary to file the visa application is available. So there may be an apostille in another country that may not be available because that agency hasn't opened up. So it's something to keep in mind as things start to hopefully get back to some semblance of normalcy. We touched on layoffs. It's going to be a big deal on two fronts. One is obviously its effect on foreign nationals who may be losing their jobs and therefore losing their immigration status. And that's going to be case by case. Same thing with eligibility for unemployment benefits, case by case, state by state. It needs to be looked at as those situations arise. And then finally, unfortunately, and I've been with the firm for a long time, seen nothing ever like this, but situations where there have been major economic downturns. that usually results in a backlash towards immigration. So I think we can anticipate, probably before the end of the year, some additional restrictions around employment-based immigration, unless things get better very quickly. Because when the economy starts to struggle, people in Washington and in the media tend to turn to immigration as one of the causes, even though it's usually one of the solutions. So those are just some overarching thoughts we wanted you to keep in mind. We can turn it over to questions if that works for everybody.
Thank you, Scott. Thank you, Alexandra and Erin. And we received a few questions. The first one is from Björn Felber. Björn works for the American subsidiary of a French company based in Boston. He's currently stuck in France waiting for his visa renewal. Björn?
Yes, hi. Can you hear me well?
Yes.
Yes.
Yeah, just wanted to know, we are stuck in Europe, and I just wanted to know if there is a chance that the travel ban will be lifted in some of the European countries, or for some of the European countries, or if it is more likely that the ban will be lifted for Europe as a whole, because yeah, the situation in Europe is very different from one country to another, and we might be able to go to another consulate in Europe.
I don't think we have any insight on that. I probably read what you read. So it's going to be up to some, I guess, combination of country decisions. Obviously, there's been some countries that have been extremely sort of liberal in their approach, like Sweden, and whether or not the EU is going to mandate that member countries open up at the same time versus individual countries. I don't think we have any direct insight on that.
Okay, thank you.
Thank you.
Yep.
We have a few questions from Nicolas Christison. Nicolas works for the French school, and he had a few questions. Nicolas?
Yes, hello. My question was regarding green card application, and from what you've now presented, it sounds as though those are still being processed, but the timing for the applications will be prolonged. Is that the right takeout?
Exactly.
Well, I guess it would depend. Erin, you want to take that? Go ahead.
Sure. Feel free to jump in. So processing continues and green card applications can still be submitted. Where the delay is now is that if you were already scheduled for an in-person interview, that will be postponed until further notice when the government resumes in-person services such as green card interviews. So the applications will still continue to process, but where you could see delays is being scheduled for an interview or being rescheduled for an interview. If you haven't gotten to that stage yet, your other applications will still pend and go through normal review procedures. But the open question now is what type of backlog will be created by the suspension of green card interviews over the past few months. Does that help answer your question?
Yes, it does. And then my secondary question off the back of that is, given that I'm still getting my head around the timing of how it all works, I believe there was also applications for the adjustment of status, and those, I believe they will keep going.
Yep.
If there is such a delay to the point that that goes beyond when our current visa is valid to, and therefore our visa has expired and we're still in the US, what is the situation? I mean, obviously the borders are closed, you're not supposed to be traveling. So what status do you end up with?
Sure.
No man's land.
Right. So this, I can give kind of a more general response to that. It would require kind of an individual analysis of your particular visa status and expiration date. But if you have an underlying, say, non-immigrant or temporary form of work authorization and a pending adjustment of status application, depending on your current status, you may still be eligible to renew your underlying visa status or work authorization directly with USCIS, as opposed to traveling to renew that. Again, that can vary visa type by visa type, so that would require some individual assessment. But also, when you have a pending adjustment of status application, even though it sounds kind of like an interim measure, your status, so to speak, would be an adjustment of status applicant. And assuming you submitted an application for advanced parole or travel document, which right now wouldn't really offer you many benefits, but also an employment authorization document, those would still process with USCIS and would allow you ultimately, once approved, an independent form of work and travel authorization while waiting for your green card interview and green card issuance.
Thank you, that's clear.
Great, you're welcome.
Okay. We have a question from Muriel. Muriel has a question about a French artist waiting for an O1 visa. So it's very specific. Muriel? Muriel, you can ask your question. So I'm going to ask Muriel's question. So that's the situation of a French artist waiting for more than 5 months for an O1 visa, who had to go back to Europe.
Hi,
Muriel.
Hi, I couldn't unmute my microphone. Yes, thank you, Ludivine. I was telling that I'm here with an E2 visa, so I'm not anxious for myself, but I'm anxious for my son, who is waiting for a renewal of an O1 visa. He has been waiting for more than 5 months now. We know that they received the file, but they didn't do anything about it. And while he was waiting, he had exhibitions in Europe, in Paris and somewhere else. So he went to Europe and he came back just 1 week before the famous coronavirus. And he is here with an ESTA now. So we know that he has to go back somewhere in Europe, in France or somewhere else, to a US consulate to make his visa stamped in his passport, if he has one, but all the consulates are closed now, and his ESTA will expire in the last week of May. So can he ask for an extension of his ESTA while he is waiting for his O1, or can he, if he has his O1, can he ask for a change of status here?
Hi, this is Alexandra. I can speak to that. So with ESTA, there are no extensions or changes of status that are allowed. The only extension, which really isn't an extension, is satisfactory departure, where he would get in touch with the deferred inspection and they could decide to grant a 30-day additional time to leave. And then if he's still not able to leave, then an additional 30 days after that. In terms of, yeah, so he could maybe get an additional 60 days if he's able to work with deferred inspection, but it is discretionary. And then for the O1, you're not allowed to change status, so he would have to leave the United States and then either process a visa and come back, which of course, will take a long time since the consulates are closed right now.
So no extension for ESTA and no change of status for O1.
Yeah.
Okay, thank you.
Correct.
Okay, and the next question is from Erica Rodas, who is based in New York City.
Hello. Actually, my question was answered at the beginning. It was also regarding the EU travel ban and restrictions. So, but that was my only question. Thanks for answering, though.
Thank you, Erica. And I have a question that I received at FACNI from a couple of members. How do you prove your status when you are a green card holder and you are in the process in renewing your green card? How do you prove your status?
feel like
Erin, why don't you go ahead?
Sure.
Sure.
So if you're renewing your green card, if someone has a 10-year green card, you don't lose your permanent resident status. And so if you're not traveling, it's not really an issue. But upon filing for the renewal, the U.S. Citizenship and Immigration Service should issue a receipt notice that shows that the renewal application is pending. So that receipt notice for the pending renewal plus the current green card is proof of permanent resident status.
Okay, and so this would be enough to apply for a job?
Yes, that gets kind of into the I-9 employment verification compliance, but yes, that would be sufficient.
Okay, thank you, Erin.
You're welcome.
Do we have any other questions? Oh, so I think we are good. Thank you again, Scott, Alexandra, and Erin for sharing your expertise. We were delighted to have you. I invite people who did not ask questions in the chat room to contact Scott and his team directly. This webinar today was made possible thanks to the support of FACNI sponsors. And we are organizing a few webinars in the upcoming weeks. We invite you to visit our website at faccne.org and the BABC website for upcoming webinars. Thank you and have a nice day.
Thank you. Appreciate it.
Thanks, everyone.